Good afternoon and welcome to the April 28th, 27th. Oh, there we go. The April 27th meeting of the Senate Judiciary Committee. We're going to open the public hearing today by hearing House Bill 504 and recognize prime sponsor Representative McGuire. No? Representative Wallner. Sorry. No, it's that we're in a different room, and I'm not like it kind of throws you off a bit. Good afternoon, Representative.
Thank you, Senator Carson, and members of the committee. Member of the committee, yes. I'm Mary Jane Wallner. I'm a state representative from Concord Ward 5, and this is really a pretty clear bill in that it basically does two things. The first thing it does, it allows the chair of the parole board to use substitutes of previous people who previously served on the parole board. And he's asking that he have 5 days a year that he could use a substitute, and they would be paid, that substitute would be paid $300 a year, $300 a day. He often finds himself in a position of not having enough of the regular members available for the parole hearings or the revocations. So in order to go forward, he would be able to use someone who previously served, so they would understand the process. It wouldn't be like getting someone who didn't understand the process. So that's the first part of the bill. And the second part of the bill is to increase the reimbursement to the parole board members. The chairman himself is a state employee. The other 4 members are paid with a stipend. And we're looking to raise the stipend for the vice chair, who does a tremendous amount of extra work. And Chairman Phillips is here and can talk to you about that. And we're looking to raise that reimbursement to $40,000 a year. And each of the others, there are 3 other members, raise each of them up to $30,000. This is a job that really entails a lot of work, a lot of thought. It's important to not only the person up for parole, but also to the public. This is a very serious undertaking. It's been very hard to recruit members of the parole board because it is a tremendous workload. Last year, they did over 1,000 parole hearings and revocation hearings. So you can see that the workload is very heavy. And Roger Phillips, who is the chair, is here, and he's really much more, he's going to be able to answer all your questions, I'm sure. But I'm glad to answer any questions.
Thank you very much, Representative. Are there any questions? Senator Whitley.
Thank you, Madam Chair. Thank you for taking my question. I see that there's an appropriation in the bill, and I'm wondering if the House had put it in, if you all put it in your budget.
No, it's not in the budget. It's still just in this bill.
Oh.
This is a standalone bill. It is not, did not roll into the budget.
Okay.
Thank you.
Thank you, Representative. Just a question.
Yeah.
So right now, is the vice chair receiving what it currently is $300 per day, or?
No, the vice chair now receives $20,000 a year, and this would raise their stipend to $40,000. And I think Mr. Phillips can talk to you about the responsibilities of the vice chair, and that the vice chair does have a lot of added duties that they undertake. And looking for parole board members, you need to have people who have they're either attorneys or they have worked in the prison system or in some area of law enforcement. So it's sort of a very specialized, kind of a specialized job that we're looking for people to do.
Thank you.
Thank you.
Are there any further questions? Seeing none, thank you very
Great.
much, Representative. Next, we're going to call Representative McGuire.
Thank you, Madam Chair, members of the committee. For the record, my name is Dan McGuire. I represent the town of Epsom. All three bills that you're going to hear this afternoon came to my section of House Finance last. We passed them all without much trouble, so I thought I'd be here to answer questions such as the question that you, Senator Whitley, just asked. So this bill in particular was the only one of the three that had any sort of mild objections, simply because some members felt doubling someone's salary was a little excessive, and so in my mind, I agree with Representative Wallner that this is it's a complicated job. It requires very experienced people. These aren't big numbers, et cetera. So I didn't have any problem with this, but a couple of members did. So if you felt you wanted to trim things, the main thing you wouldn't want to trim, I would say, is that $300 a day, because that's something new just for fill-in type people. And so including allowing fill-ins, which are not allowed now. So that's an important part of this bill. Now, as for the question of whether this is in the budget or not, so it's sort of yes and no. So this bill is not part of House Bill 1 or 2, but it is on what we call the surplus statement, which means that we are accounting for it in the overall grand scheme of things in terms of how much money we have, how much will end up in the rainy day fund, and so on. So, technically it's what's known as a legislative special, but it is accounted for in all of our numbers. So, and I'm happy to answer any questions.
Thank you very much for your testimony, Representative. Are there any questions from the committee?
Okay.
Seeing none, thank you. Which one of you would like to go first, Mr. Phillips or Mr. McKay?
Why don't we come up together? Would that be all right?
That would be perfect, thank you. Just make sure that you identify yourselves before you speak, so that way Mr. Schulze can record your names accurately. Good afternoon, gentlemen.
Good afternoon, Madam Chair and members of the committee. My name is Roger Phillips, and I am chairman or chairperson of the Adult Parole Board. With me today is Jay Mackey, who is the Director of Operations. Are we able to hear all right? Okay. Just by way of background, the Parole Board is a 5-member board, of which I was appointed chairperson 1 year ago, although I've served on the board since 2019. I'm a full-time, unclassified state employee, but the other members of the board are just part-time. And by way of background, the board holds hearings on Tuesdays and Thursdays of most every week. On Tuesdays, it's parole revocation hearings. And there are usually 15 to 20 hearings scheduled for a hearing day. That really depends on obviously how many warrants have been issued and whatnot. And sometimes things go very smoothly on hearing days, and other days we have to spend more than an hour or more on one particular case. So sometimes we go 8:30 until 1, but it's not unusual to go 8:30 in the morning till 5 in the evening. On the parole days, those are Thursdays. And to give you just a little bit of an idea of what has to be done, excuse me, there's one thing that I have suffered for since I was a child, and that's hay fever. And now that the pollens are out, so if my voice goes a little bit, or if I have to cough a little, I'm not spreading a disease. It's just merely the hay fever with which I suffer. The parole packets that are reviewed by each member can be anywhere between 30 and 60 pages. And when I first joined the board, those were all in paper packets, and a large cardboard carton was delivered to my house before a hearing, and that's what we had to go through. Fortunately, everything now is digital, and we've been issued laptops, and we're able to review it. But there is still, as I count them, 23 different sections that should be looked at in going through a parole packet. So the actual time to do, to properly prepare can take anywhere between 8 and 16 hours to do for a parole packet. Those who are also have a revocation hearing that week, that can take 6 to 8 hours to do just the preparation for that. So although there may be only the 2 hearing days, the prep time can be the other 3. So I mean, you can easily do 5 days a week in preparation. As indicated earlier, the first part of the bill would allow me to call on someone who had previously served and either resigned or term had ended, and to substitute for a day. With a 5-member board, you can imagine that there are times that not 3 members are available on a given hearing day. In 2022, we had to cancel 2 hearing days. That hearing, the statute requires that there be 36 hearing days a year. We more often do 44 to 45. However, we want to make certain there's sufficient time in the day to go through the materials. And the hearing days are important. And in revocation matters, a hearing must be available to the parolee within 45 days of his or her arrest. And that's why sometimes that it would be important to have a substitute to be able to sit. Since that work is going to be on a laptop, it would be up to me to train the substitute, get the laptop to him or her, and go through the process. But at least it's not unlike in the judicial system where we have senior judges or those who retired who come back and act to help out. And I think it's just a safety valve from my point of view. So I think that would be important. And I think a $300 per day stipend for both the hearing and the prep time is appropriate. And that's why we've asked for the $1,500. On the other parts of the bill, which are rather important, I just wanted to go through a little bit about, from my point of view, it's an important public safety issue, that we parole those who constitutionally deserve the right after they've been rehabilitated, and we believe they will not reoffend and become good citizens. On the other hand, I think it's also important that those who need additional time for rehabilitation not parole out before programs are completed, or we think there's a likelihood that they will meet the criteria of not reoffending. So initially, when the 9-member board was reduced to a 5-member board, the initial legislation indicated that the compensation for that would be the $30,000, and I don't know if in that bill they had $40,000 or not in that. I wasn't privy to some of those things, even though I was on the board. But I do know that it was reduced during the legislative process. And what I'd like to do is just tell you the difficulty. For instance, we had a person resign, and I had to go out to try to find someone who would be willing to apply to the governor and council for appointment. It took almost 5 months to get that accomplished. To give you a little bit of background, there are two attorneys that are required under the law to be on the board. I am one, and there's one other. And we also have to have someone from law enforcement or corrections background, another one from a criminology background of some sort, or a teacher, and one from the general population with no particular designation of what would be required. And, you know, we're very lucky, I think, because we have a retired captain from San Quentin, he used to live in California, as one of our board members, and he's also serves as the vice chair. We also have a person who has police experience. In fact, he was injured with a gunshot in the line of duty years ago, and he teaches criminology at the post-secondary level. And we also have one who serves who's a retired surgeon, and we're very fortunate in having someone with a medical background, and he was instrumental in doing the proposal that we had recently to change the medical parole. So we have a very strong board right now. The difficulty we have right now is that they're all males. I would hope that as time goes on that we could have more diversity on the board. And I tried very hard to find a female attorney who could fill that last position that we needed, but I was unsuccessful. And I think I was unsuccessful kind of for two other reasons too. Because I think the compensation just isn't sufficient. For instance, someone could retire and be of counsel to the firm and earn considerably more than $30,000 a year and not work as hard as what parole officers do. And so I think it's important that we, and I was born and raised in New Hampshire. I understand that we have a volunteer legislature, and we, and a lot of us do a lot for public service. But I think when we're doing something as important as releasing folks out into the society, we want to make sure that the board is well-trained, they're competent, and they make good decisions. I have to admit that I can't predict the future, and I don't always know how someone will react out there. But the best we can do is to see how well they've done behind the walls, what programs they've completed, what their risk assessment is, and we look at all of those things. The other issue that I think was very difficult is that there is a lot of stress associated with the board. It's not easy to hear and read about the child's sexual abuse or the terrible things that happened in assaults and robberies and homicides and whatnot. And just to give you an example, we had a member of the board who had a great deal of experience in law enforcement. He was a police officer in a large metropolitan area outside of New Hampshire, served there several years and then transferred to the federal government and had lots of experience in drug enforcement and came on the board. He was a friend of mine, knew him well. And he couldn't sleep nights. And I don't know whether it was a combination of all he went through in his prior careers, plus what was going on. But when he heard the stories of the victims and what they went through, he just came up to me and said, I can't do this anymore. I can't sleep. And Jay and I recently went to Kansas City for a parole conference that really national and international. And there was a 3-hour session that I attended, and we're not alone in that. There are lots, this session just addressed the stress involved and the difficulty with being a parole board member. And talking about some of the things that we could do, whether it's the meditation or others, and the deep breathing exercises to try to get rid of stress and to share something and not hold things in. So in essence, that's why we had, because I think it's very important to keep and attract, that's why I had requested the 30,000. And then the final part of the bill is for $40,000 for the vice chair. And right now, only the chair and the vice chair issue warrants. And when we got involved with a new digital system, in order so that we could track things properly and make sure things were filed properly and went into the right, drives that we have, and that the warrant was processed properly and got into NCIC. That's why so that the vice chair and the chair are the ones who sign warrants. And I also want you to know that warrants aren't signed just because there's probable cause. We also require that they tell us what are the other things that they tried to prevent before they resorted to the warrant. What other activities were done? For instance, if someone started to use drugs again, what that person did as an alternative sanction to get that person into rehab, or to get the person back to NA or AA meetings, whatever it might be. So alternative sanctions are always required before we issue a warrant, except for those who might commit a crime. And those who recommit a crime, obviously, there isn't time to do something for an alternative sanction. So, as our representative, this had bipartisan support below. Representative Sytek, along with Representative Wallner, co-sponsored this bill, and we would hope the Senate Finance would approve it. So I think that's a nutshell as best I can tell you why I think it's important for the increase, and why I think it will help us in the future either keep people on the parole board and also to go out to get people to apply to be new members. We will have to be one member this year that's going to be appointed, one member in 2025, and two more in 2026. So it's all staggered, but I think it's very important that we have the increased compensation and there be something more for the vice chair, who does do a lot of work. So.
Thank you very much for your testimony. Are there any questions from the committee? Just for your information, Mr. Phillips, we're a policy committee, so we don't deal with the fiscal impact. If we decide that we think the policy of this should go forward, you will have another hearing in Senate Finance to address the finance issue, much like you did in the House.
We went before Senate Finance, and I explained what we had proposed, and they said, well, you go forward with the committee and explain why you need it, and if they vote in favor, that's fine with us.
Okay, thank you.
All right.
Mr. McKay, do you have anything that you'd like to add?
I'm Jay Mackey, Director of Operations. I was only going to really be here to answer any questions you may have that I may be more familiar with than Chairman Phillips was. To piggyback on the recruiting effort, I had a colleague of mine who I used to work with in corrections, who became an attorney and a prosecutor when we were looking for an attorney. And when I started to describe the amount of work that's involved, he said he could not devote that much time to. So just to kind of stress the amount of time and effort that goes into parole hearings and parole revocation hearings, I just really want to stress it. It was 5 months of a vacancy, as well as with the other part, I was the one at the time scheduling hearings when we had to cancel, and rescheduling hearings, being within the timeframes and the guidelines within the statutory timeframes is not easy. And to be honest, we actually almost had to reschedule today's hearings because we had to be here. and we almost didn't have a third member to sit. But somebody did step up and rearrange their schedule to be able to do that. So it's not an easy thing to do, to reschedule all these hearings, because people, the inmates themselves don't want to be pushed back any further to be heard for their release, as well as, staying within those statutory guidelines for the 45 days within 45 days of arrest to have a parole revocation hearing. It's very hard to reschedule all that, so that's why this was proposed.
Okay, thank you very much. Are there any questions for Mr., is it McKay or
Mackey.
Mackey? Okay, seeing none, thank you both very much for your testimony.
Thank you very much. We appreciate it.
Are there any other members of the public that would like to speak to House Bill 504? Okay, seeing none, we'll close the public hearing. Thank you. Thank you. I know you're all set, Matthew, you're all set. Okay, we're going to go ahead and open the public hearing on House Bill 46 and recognize the prime sponsor, Representative Harriet Gaithright. Good afternoon, Representative.
Good afternoon, Madam Chair and committee members. HB 46 has been, my name is Linda Harriet Gaithright, representative out of Nashua, Ward 9. HB 46 has been quite interesting to several amendments to finally deciding on we would like to have a committee to really truly deep dive into the many, many bills that we received in terms of bail reform. I think we have outdid ourselves over and over again, whether it was a House bill or Senate bill or whatever, but there's so many bills. So we want to do justice to this system of strengthening the bail system. So with that said, our last amendment was to have a committee, and it was pretty detailed what we're sort of looking for in the committee. And I believe that at one point it was said that we were actually going to, or deleting the magistrates, removing the magistrate, or not magistrates, the commissioners. And but what we wanted to look at, whether if that is necessary, or can we use both magistrates and commissioners? So there's a lot more to be said in terms of strengthening the bail reform system, but I'm here to ask you to vote yes for the committee to be formed.
Okay, thank you very much for your testimony. Are there any questions? Representative, can I ask you how or why did you file the bill?
The bill was brought to me, was literally given to me by the judicial system
Okay.
in New Hampshire. It came in as a bill, and we tried to enact it last term, but it was non-germane to another bill. So, after talking to the clerk about it, and he said, you know what, make sure you put it in, the next term, and that's what I did. And I've been working pretty closely with Mr. Head for the last 2 years, actually, about this bill. And the last thing that we decided to do is to try to get a committee together and really do a deep dive into the real issue and see if we can come up with something better that's, even for the defendants as well as for victims. So.
Okay. And I don't mean to put you on the spot,
That's okay.
Representative, because this is an issue that I've done a lot of work on for probably about 5 years. And we were meeting with the Chief Justice and Mr. Head, both the bail commissioners and I, during the summer.
Mm-hmm.
And so when we saw that a bill had been filed, people were like, what the heck happened here? How did this happen? And of course, the court system wasn't really responding to our questions. So I couldn't figure out how that happened, but I just want to go on the record saying that if this passes, I will hopefully, I will be volunteering to serve on this as well. So,
Oh, great. And I hope I get to serve as well.
well, you have to speak to the speaker
I
about
know.
that one. So, are there any further questions for the representative? Okay, seeing none. Thank you very much, Representative.
Thank you.
The chair will call Frank Knack. Good afternoon, Mr. Knack.
Good afternoon. Thank you so much for the opportunity to
Thank you.
testify, Madam Chair. My name is Frank Knack. I'm Policy Director with the ACLU of New Hampshire, and we are here in strong support of HB 46. As Representative Harriet Gathright mentioned, there have been numerous attempts this session, as well as previous sessions, to, from our perspective, roll back important bail reforms. And those attempts have been done without any evidence to show that the current bail system is failing. We've heard numbers, I think more recently we heard the Manchester chief talk about 700 people who they found in their records to have been rearrested while on release. But what we haven't heard from anyone is how the current system has failed in any of those examples. So where have bail commissioners failed to hold people who pose a danger or a flight risk, which they're allowed to do under current law for any offense? Where judges have failed to hold people, we've just heard anecdotes without specifics. And so we're excited about this opportunity because instead of holding people without, depriving people of their liberty without any data to support that, this gives us an opportunity to actually look at the facts. What's actually happening is, in fact, bail commissioners failing to do their job, failing to utilize the multiple tools that they have under current law. And so I have in the attachment to the handout I just gave you all of the all the ways in current law that bail commissioners or judges can hold people. And so are they failing to do that? If so, does that warrant us moving away from bail commissioners and moving towards a magistrate system? And again, the beauty of this, so for example, SB 252, which passed out of this committee, which would have forced people to be held before they get before a judge, for 13 separate offense types without any individualized discussion about those cases and the facts in those cases. The rhetoric behind why we need that is because bail commissioners were inappropriate. We need to make sure those people get before a judge. And so the beauty of moving to this type of system is that everyone will get before a judge immediately. And so if the concern truly is bail commissioners, then moving towards a magistrate system will ensure that everyone gets before a judge and that those issues are resolved, and you do so without having to hold people unnecessarily. So it's the best of both worlds. So really appreciate your time and consideration on that. Urge passage, and thank you, and happy to answer any questions.
Thank you very much for your testimony, Mr. Knack. Are there any questions from the committee? Okay, seeing none, thank you very much. Are there any other members of the public that would like to speak to House Bill 46? Okay, seeing none, we'll close the public hearing. Thank you, Matthew. Oops.
Good afternoon, Madam Chair. Thank you, and thank you, honorable members of the committee. HB 379 simply states that on the eviction notice given to tenants that the contact information and procedure for acquiring legal assistance through legal assistance for those eviction proceedings will be on the notice of eviction. So just the contact information and how to go about contacting them in case they qualify. It does not give a guarantee that they will have that assistance or that they will qualify for that assistance. It simply says, here's who you go to. So the history of HB 379 actually started life as a bill that created an empty bucket, a $1 bucket for legal assistance to provide lawyers to tenants who were experiencing eviction. The reason that I initially did that is through conversations with Senator Hassan's aides. It looked as if, and it may still come to fruition, that we might be able to get about $3 million of federal funding for such a program. However, by the time that this got to a hearing in the House and an exec in the House, that we had not received more assurances that would happen. The House committee unanimously amended it to simply say, here's the contact information for legal assistance. So it's an extremely simple bill. It unanimously passed out of committee and also the Finance Committee and on consent calendar both times in the House. I understand legal assistance actually has prepared another amendment. So the process in the House committee, the House committee came up with their own amendment to do this before legal assistance had a chance to make their own. The legal assistance's amendment, which I think may have been sent to you, but I'll certainly make sure that you get it if you don't have it, adds the writ as well as the eviction notice. But I'll allow legal assistance to speak to that in particular. The main issue here is that everyone has a right to legal counsel in a court proceeding. Everyone has that inherent right, but not everybody has equal access. So landlords who are in a business of doing this landlord business frequently have a particular lawyer that they go to for these things, are very well versed in the procedures involved in evicting a tenant, and kind of go in very, very prepared. A tenant, especially a lower income tenant that is more likely to be renting to begin with, doesn't usually have that kind of information, doesn't have that background, doesn't have a lawyer on retainer or standby, or has been through these proceedings repeatedly, isn't armed with that kind of information. And so they frequently go into these court hearings on eviction proceedings completely unprepared, not knowing how they should proceed forward. And in fact, we had the reason that this was originally put in, there's multiple anecdotal stories of judges who really wanted to find for the tenant, but the tenant lacked the magic words, either the procedural motion that they needed to make or whatever, but the judge knew that there was something procedurally wrong and yet was not able to do anything and had to find for the landlord in those situations. So having access to that by right, that you have that right to have the legal counsel with you, but not having access really puts the tenant at a disadvantage. And so all this does is let them know that there is help out there should they qualify for it, and give them the tools to acquire that help. I find it, I'm incredulous that anyone would be opposed to this. Again, it was unanimous out of committee both times and on the floor, because if you're opposed to it, you're saying that you want to keep a tenant in the dark so that they do not have the ability to get their legal counsel that they should have by right. In other words, you as a landlord want an unfair advantage in court and not have the tenant be able to have the advantage you have of having legal counsel in that courtroom. So with that, I will wrap up and open up to questions.
Thank you very much for your testimony, Representative. Are there questions from the committee? I have a quick question. I think we all know that there's different types of tenants. Some tenants received they receive financial assistance either from the state or the federal government. I know with Section 8 housing, again, that's a voucher that they get from the federal government to pay for their rent. Does the federal government give them any kind of a warning and list their rights when they get Section 8 housing, that they have the right to an attorney if upon conviction? Not conviction, eviction. Sorry.
My understanding is those eviction processes, despite the fact that the financial assistance for those properties come from the federal government originally, those eviction processes still happen in the state, so that's still under the purview of the state.
My question would be if there were additional protections for those who receive federal assistance.
So so there are additional, broadly speaking, there are additional protections. I think I can't remember which Senate committee now, but for example, if you're a victim of domestic violence, all you have to do is attest to the fact that you're a victim of domestic violence and you can leave your lease. So that's an additional protection you receive. But in terms of eviction, again, those eviction proceedings happen in the court in the state.
Okay.
So we are the ones in charge of giving those protections, not the federal government.
Okay, thank you. Are there any further questions? Okay. Seeing none, thank you very much.
Thank you.
The chair will call Nick Norman.
Thank you very much. I've been before the committee many times, so just a shortly recap. My name is Nick Norman. I advocate for property owners, landlords around the state and the Apartment Association of New Hampshire and the New Hampshire Rental Property Owners Association. I do have some written testimony that I can pass around. So there's some concerns with the bill, not so much that tenants would be notified that they can use legal aid, New Hampshire legal aid. I think that pretty much all tenants know that that's an option for them. I can't say it's 100%, of course, but it's well known in the landlord-tenant world that New Hampshire legal assistance represents tenants and can give them assistance. There's a concern structurally if you put the way this is worded, a demand to have this on the eviction notice, that could be interpreted as some kind of right to be told. And particularly—
Excuse me, Mr. Norman. Ms. Reed, Representative Reed, please do not do that. We are paying attention to Mr. Norman, and with you gesturing and showing things in the audience, it is distracting for the committee members. When the public hearing is over, you'll have every opportunity to reach out to Senate members, but please do not engage in that behavior in here. Thank you. Please continue, Mr. Norman.
Thank you. So there's a possibility that because landlords certainly won't know all the different methods of how you would initiate support through NHLA, and the correct contact info, which maybe could change, that the tenant or someone defending them could then make a claim, this eviction notice is now defective. Because now you've got this additional wording that's supposed to be on here, which refers to their process of working with NHLA. So we would like to see that the court develop that form so that the court can make sure that the right information is on that eviction notice. And the eviction notice cannot be called defective because there's something that changed in the process. Secondly, we do have an amendment that I'm going to give to you that will address our concerns. So we're not saying that we're opposed to having something of this notice on the eviction notice. We just want to clarify and handle these concerns. So basically, we definitely want to see that the court develop the form is not left to individual landlords it's not their business to know all about NHLA and the processes for contacting them and getting assistance. And that the form is not potentially called defective because something didn't happen right in the notices on the form. So I'm going to pass to you an amendment that we've worked on quite a bit, actually, to get the language needed. You can pass this around. 1, 2, 3. Thank you very much. And I'm very happy to take any questions, and if you're working on something that would modify this amendment or anything else, I'm happy to work with you on that.
Thank you very much for your testimony, Mr. Norman. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Are there any other members of the public that would like to speak to House Bill 379? Please come forward and state your name for the record.
My apologies, Madam Chair. I signed in late. I was distracted. But I'm Dawn McKinney. I'm the Policy Director at New Hampshire Legal Assistance. And I just wanted to, address this bill. And I can no longer wear glasses and read at the same time. So as I think you've already heard kind of the original intent, and we actually did provide alternative language on the House side in committee, that it just didn't work into the process in time and so forth. So what you have in front of you it was obviously what was passed by the House. We also suggested an amendment, the same amendment that we suggested the House, we've shared with the committee, and essentially it is to,
Thank you.
I don't know that we necessarily disagree with Mr. Norman, who you just heard, in terms of not specifying New Hampshire Legal Assistance. I would think it makes more sense to not have a specific organization in the statute. In particular, we actually aren't the ones, we don't do the intake process, for example. So technically, a tenant who received an eviction notice would want to contact 603 Legal Aid, which is our sister organization that does the intake process and triages and then refers cases to us that meet criteria, the indigent criteria and things like that. So just for simplicity, I think it makes more sense, a more general language, which I did provide, and I'm happy to work also with, I haven't seen Mr. Norman's amendment, but I'm also happy to work together on, language that we think could work. I think everyone is probably clear at this point about the differentiation between, right to counsel versus affording counsel. That was something that was really important to the House Committee for folks to understand. Of course, everyone has a right to counsel, but the ability to afford it is the issue in question. This does not do anything to address the pay for anyone's counsel. So just to clarify that, I would also just point out that we'd be happy to work also with the courts on what that language would be. We think that is the best place for it to be decided, the language to be dictated by the courts. In fact, if you look at the current eviction notice and on the Judicial Branch website, there is extensive language about, for example, mediation that's available, and there's also extensive list of organizations that can help with legal assistance, not just New Hampshire Legal Assistance. So I do think that there are resources out there, and it's better to have the courts and maybe the various organizations that do provide those services work together on what that language might be on the website and on the eviction notice. And then also we added in our language, we suggested also adding it to the landlord-tenant writ, because that's the other document that tenants receive prior to an eviction that they might need help with. And I guess I'll just leave it at that and see if you have any questions.
Thank you very much for your testimony. Are there questions from the committee? Senator Chandler.
Thank you. Thank you, Madam Chair. And I'm not sure my question is right for Ms. McKinney. I'm not sure. It really has to do with the financial impact. There is a fiscal note, and Representative McGuire, in previous testimony, mentioned that it did go to finance and had the full support, as did Representative Reed mention that. I'm just curious as to what the Finance Committee heard and what the support was, and I guess the way to bring it back to Ms. McKinney is, what is there a financial impact that you see? And
I don't believe that there's a financial impact any longer, based on the version that came from, I think the new fiscal note from the House said that there
It
wasn't
does say
one.
that none. It does. It says
Okay,
none.
okay.
Yeah.
On the House, the reason there was a fiscal note originally was because the original bill would have created that pool that Representative Reed referred to, that would have paid for essentially people's legal representation, and there just wasn't wasn't deemed a priority, or there wasn't consensus around that. As much as I think everyone in theory would like to think that folks should and could have right to counsel in these situations, it's would have to be a commitment on this part of the state to fund that.
Thank you.
Are there any further questions? I have a question, and I'm thinking about a hypothetical situation where someone receives a eviction notice. I keep saying conviction.
That's okay.
An eviction notice, and on that notice it says you are eligible, or you should find out if you're eligible for legal assistance.
Mm-hmm.
And they call, but unfortunately, where they're calling, they're just backed up. They don't have any available attorneys.
Mm-hmm.
Now, during the eviction process, it's on a timeline, and they can't get the help that they are requesting for during that time period. Is this going to give them an opportunity to say to the court, hey, I wanted legal assistance, I couldn't get it, I'm in a backlog here, you can't evict me now because I want legal assistance? In a way, it's kind of like a de facto way to get a right for legal assistance, because they wanted it, they couldn't get it in enough time. So can they extend the eviction process because they couldn't get that legal assistance?
I don't believe that would change the process at all. There are currently, we can't possibly provide help to everyone who needs assistance going to court. And many people represent themselves pro se because of that. And we do everything we can to triage, but and to begin with, we only serve low income folks. So that's already kind of, but I don't think that is, would be a further impact on the process in terms of delays and things like that to get representation. That's not that I'm aware of, no.
Okay, thank you. Are there any further questions? Okay, seeing none, thank you very much. Are there any other member of the public that would like to speak to House Bill 379? Okay, seeing none, we'll close the public hearing. The committee will be in recess until 2:15. Did this, oops, sorry. Everyone knows we're doing this because Mr. Shelzy is going to Paris on the 19th, and we've got to get everything done before he goes. Don't worry. No sympathy whatsoever. But we're not recording anything, so you don't have to worry about everybody knowing that, so. Okay, are we all set?
Yeah.
Okay. The committee will come out of recess. Can I get a motion to go into executive session?
So moved.
Moved by Senator Whitley, seconded by Senator Chandler. The first bill we're going to take up is House Bill 31, repealing the prohibition on the possession or sale of blackjack, slung shots, and metallic knuckles. Is there a motion?
I move ITL.
Okay, we have a motion of ITL, moved by Senator Whitley, seconded by Senator Chandler. Is there any discussion on the ITL motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? No. Okay, so it's a 4-1, okay. Senator Whitley, would you like to take this one out? Sure. If you don't, I will.
No, I'll do it.
Okay.
Or something good.
I just said applies on the floor too.
Just for the to notify the public, we have the Senate President sitting in with us this afternoon. Senator Gannon, I think we all know, has been very ill, but he is on the mend. He's getting better, and he plans on being back with us next Tuesday. So the next bill we're going to do is House Bill 46, a bill we heard this afternoon, which seeks to establish a committee to study the replacement of bail commissioners with court magistrates.
I move ought to pass.
I'll second.
Okay, Senator Chandler moves ought to pass, seconded by Senator Whitley. Is there any discussion on the ought to pass motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, is there a motion for the consent calendar?
So moved. Second.
Moved by Senator Chandler, seconded by Senator Whitley.
Senator.
Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, Matthew, I'd like to be responsible for the blurb on this one. Okay, next we are going to House Bill 89, relative to posthumous exonerations. I'm going to move ITL.
Second.
And seconded by Senator Abbas. Discussion? I think that this is interesting. I think there is an issue about granting pardons. We don't do that. That is done through the governor and executive council. I would have liked to have heard a little bit more about Goody Cole. And we did hear a lot about Willard Uphouse, but I just think this is the wrong place to do this. I really think that they need to approach the executive council and have it done through there.
I don't disagree that there were some questions, and I'm just wondering, I wouldn't be opposed to re-referring it if that's something, I understand your concern that it should go to the executive council, just wondering if there is a role for us.
I could support a re-refer, and I think we could put that on the consent.
I just don't know what we would do if we re-referred it. Are we just going to hold it and then vote on it in January? The circumstances are really not going to change. There is a book written about Goody Cole, by the way.
Yeah.
So I went and bought it, so I haven't read it yet, though.
I think it's interesting to explore the legislature's role in this, in exonerations. I think I agree, it's sort of novel. But I think it is worth some sort of exploration of our role.
Senator, I don't disagree with you, but I think that should be a separate piece of legislation rather than using this as a way to do it. Just my 2 cents. So that's why I really can't support the re-referral, because what are we going to do? Senator Abbas?
Thank you, Madam Chair. So last term in the House, we had a similar bill, and I believe it was initially an ITL motion. We changed that to then allow it to be retained, and we explored what, if anything, could be done. And this says exonerate, so they did change it around, but again, the legislator is not the one that exonerates someone. So we came to the conclusion
And we really tried hard, especially out of respect for Representative Cushing, who championed this when he was a representative. So I respect for him, we really tried. And if there's anything that can come up, we just didn't hear anything that the legislature could do. So I think retaining it or re-referring it would be, I'm not sure what we're going to do by doing that. So I would support the ITL.
I think also, I would like there was no one from the community of Goody Cole to come in and really talk to us why she should be exonerated. Oh, I think it's Hampton. Here we go. It's Hampton. In fact, there is I think it's on 111. There's a barbecue place that's called Goody Cole's. Yeah. But, you know, it would have been nice to hear from the community, especially like the Hampton Historical Society, to come in and really give us some information about her and what happened to her. But we didn't really get any of that stuff. So.
Madam Chair, may I request a quick 1-minute recess to caucus?
Sure.
Thank you.
Sure.
Appreciate it.
The committee will be in recess for 2 minutes. None. All in favor say aye.
Aye.
Any opposed?
No.
Senator Carson, your mic.
Oh, I'm sorry. Okay, so this is ITL. Okay, 3-2. Okay, who wants to take this one out? Senator Abbas. Okay. Next, we have House Bill 97, establishing an additional penalty for a violation of privacy. I move on to pass. Is there a second?
A second.
There's an amendment.
Well, usually we make the motion and then we take up the amendment.
Okay, I'm sorry.
So I second the
So
OTP.
we also have an amendment. I don't know if I have it here.
No, Matthew put.
I know you, Matthew, put a lot of, can I get another copy, Mr. Schultz? Oh, okay, here we go.
Thank you.
Okay, so we have a motion of, to pass. Pending, we now have an amendment. It's amendment number 1488S. Mr. Lehman, would you like to discuss the amendment?
The way the bill came across, it simply made a second offense a heightened penalty. Typically, when you do that, you make sure that the second offense occurred after the first conviction. This is the exact same language that's used in the DWI statute to accomplish the same thing. It's in order to prevent somebody from being basically convicted twice for the same criminal transaction and getting stuck with the increased penalty.
Are there any questions on the amendment? Okay. Seeing none, do we have a
Someone
motion?
has to move the amendment.
Okay, so I will move amendment 1488S. Is there a second?
Second.
Seconded by Senator Chandler. Is there any further discussion on Amendment 1488S? Okay. Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, we have an ought to pass as amended motion, I believe, Mr. Schulzer? Okay, so is there any discussion on the ought to pass as amended
Do you need a
motion?
second on that?
Okay,
As
Okay.
amended? Carries over?
carries over. Okay, so, all in favor say aye.
Aye.
Any opposed? Okay.
Move consent?
Senator Chandler moves consent, seconded by Senator Whitley. Any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed?
I'm opposed.
Okay, 4-1. Okay, so, I will take this one out. Okay, next we have House Bill 107, relative to employment restrictions for registered sex offenders. I'd like to make a motion of re-refer,
Second.
seconded by Senator Abbas. This is the second time that we've had this bill. I would like to commend the sponsor for doing a lot of work on it. And I think there might be a little bit more work that needs to be done on this before it's ready to come forward. So that's why I'm asking for the re-refer. Is there any further discussion on the re-refer motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Okay.
Second.
Senator Chandler moves consent. Is Senator Whitley seconds. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Matthew, I will do that as well. Next, we have House Bill 156, relative to misconduct by a law enforcement officer. I move ITL.
Second.
Senator Abbas seconds. I think that there was, the testimony that we had, we already do this. And if you were to look at the Lori list, because that's what we're talking about, it's already in there. They already get in trouble for falsifying any record, lying to anybody. So I just don't see why we actually have to do this. It is redundant. And that's why I recommended that this be ITL. Yes, Senator Whitley.
So I think it's necessary to clarify in law, so I'm gonna be voting against the ITL.
Okay.
I think there was compromise language in the House that I thought was really good, and I know that committee worked very hard on that compromise language, and so because of that, I can't support the ITL.
Okay. Okay. Is there any further discussion on House Bill 156? Okay, seeing none, all in favor say aye.
Aye.
Any opposed?
No.
Okay. Senator Abbas, you want to take this one out?
Sure.
Okay. Okay, next we have House Bill 135, prohibiting no-knock warrants. I'm going to move ITL.
Second.
Seconded by Senator Abbas. Is there any discussion?
Yeah.
Yes.
Thank you, Madam Chair. I'm disappointed by that motion. I do feel like what came over to the Senate, they had worked on a ton. I think the initial bill was much broader, and I think what we had before us was, very narrowly tailored. Representative Roy, the chairman of the House committee, said, and I agree, that the amendment really struck the balance between public and police safety. I mean, I really do believe that. It also, the amendment that the House gave to us was clearly in line with how federal law enforcement is to act. And so we would just be applying that to all of our law enforcement, so we would have consistency across the board. I didn't hear sort of specific concerns with, you know, from law enforcement, we did hear concerns, but I didn't hear specific concerns about why this narrowly tailored amendment would be problematic. And in fact, I do have an amendment prepared that was very responsive to the detailed changes that the state police had suggested, and I thought that you know, narrowed the bill even further. And so I thought this bill had a lot of merit. They had worked really hard in the House to narrow it so it could balance those interests, and I'm disappointed that we're not going to be able to support it today.
Thank you very much for your comments. Are there any further comments on this? Senator Chandler, you look like you want to say something.
I do. I agree that this, I believe, the bill as it came to us was a reasonably good bill, and I really am sorry that we don't have the opportunity to discuss the amendment that Senator Whitley prepared, because I think that amendment really did address the concerns we heard, and I'm sorry that we don't have that opportunity, but thank you.
Thank you. I will say that I do think that this bill needs a lot more work than even goes beyond the amendment that Senator Whitley provided us. They're looking at changing a lot of the terminology. I think there were questions about whether or not we even use no-knock warrants. I think we both know, we all know, we had testimony, they said we don't use it, and then we heard they do. So I think that that's an issue that needs to be clarified. And I'm also not really concerned, but there was discussion that the fact that they have to go to court. You just can't get a no-knock warrant. You must go to court. And I think what needs to happen is that procedure perhaps needs to be laid out a little bit more about what happens, what are the criteria really for getting that no-knock warrant, even if it is warranted. And so that's why I recommended the ITL. I hope that the sponsors will go back and really take a look at this and resolve the questions that we had, because I do think that this is going to be, there's just a lot of things that need to be resolved beyond Senator Whitley's amendment. So, yes, Senator Whitley.
Yeah, I do want to correct that we did hear testimony, particularly from Manchester, that there are at least 15 to 30 no-knock warrants in the city. So it does happen, and you know, I guess my concern with that, clearly it is happening, and I think without any protocol, I think this bill would put protocols in place, and I think we are leaving, without memorializing what's, frankly required of federal law enforcement officers, I think we are putting everyone at risk by not having the protocols, I think, that were narrowly tailored in 135, and which are, very similar to what the Attorney General uses for federal law enforcement. So I thought it was ready. I hear your concerns, but I am disappointed.
Okay. Senator Abbas?
Thank you, Madam Chair. I don't believe the amendment prepared addressed the strict exclusionary rule of the evidence here. So if there's a good faith application for a no-knock warrant, and it turns out down the line that was challenged in court, all the evidence would be excluded. Now, under normal circumstances, what would happen is this is called the fruit of the poisonous tree analysis. If you're able to obtain the evidence through other means, it's not automatically excluded. This would require it to be excluded no matter what. Even if it would have been a situation where the police would have been able to get an irregular warrant with a knock and announce, but the no-knock warrant was inappropriate. All the evidence would be excluded. We could be talking about a large fentanyl operation, and because if they applied for the no-knock warrant and it didn't work out for whatever reason, they didn't meet the burden when it's challenged down the line, all that evidence would be thrown out. So I think this goes too far in that regard. So I haven't heard any instances in New Hampshire where no-knock warrants were being misused, or any incidents where when they were used, that the law enforcement didn't follow the training protocol. So I think that's a credit to our law enforcement now. And I don't see a need for a change in the state based on what's going on in New Hampshire.
Okay, thank you, Senator. Is there any further discussion on House Bill 135? Okay, we have a pending ITL motion. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed?
No.
Okay, it's 3-2. Senator Abbas, will you take this one out? Okay. Next, we have House Bill 200. I'd like to move to re-refer this back to the committee. Is there a second?
Second.
Seconded by Senator Chandler. I see there's a lot of merit in here, but there's a lot of problems. This one just is not ready, but it is worth working to see if we can resolve this. So again, we have the pending motion of re-refer. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Is there a motion for consent?
So moved.
Moved by Senator Whitley, seconded by Senator Chandler. Is there any further discussion on the consent motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, and Matthew, I'll take this one. Okay. Next, we are going to go to House Bill 201, relative to changing the penalties for driving without a license. I'm moving ITL. Is there a second?
Second.
Seconded by Senator Abbas. Okay, I understand why this came forward, but I think this is an issue of really about public safety. And I, to be honest with you, I really didn't hear a really compelling reason why we need to change this. That's where I'm at. Senator Whitley.
Thank you. So I thought this bill had a lot of merit. I mean, it's really only for the first time offense. We heard, I think, significant testimony from the immigrant rights community that this is really meaningful for our low-income residents, for our younger people, and all those who are barred from obtaining a license because of their immigration status. I think, you know, we should be in the business, I think, of supporting our vulnerable communities, and I think this bill did that particularly because it was, and I don't think it was a public safety issue because it really is only for the first time offense.
Senator Abbas.
Thank you, Madam Chair. It's very rare that this is someone who's prosecuted for this as a standalone charge. It's usually trailing something else. And I hear quite frequently if a person's license, if they don't have it or wasn't renewed, if by the time they show up to court, they have squared away some of that paperwork, well, they usually drop the charge. It's a common practice. That's obviously the discretion of the prosecutor. So, and having a 12-month look-back period for a subsequent offense, drunk driving, it's 10 years. So have a 1-year look-back period, that's incredibly short. So I would support the ITL.
Okay, is there any further discussion on the ITL? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed?
No.
Okay, so we got another 3-2. Okay, ITL. Senator Abbas, would you do this one as well?
Sure.
Okay. Okay, next we have House Bill 266, which I believe is relative to notice and public access requirements for hybrid and virtual agency public comment hearings for rulemaking. I'd like to move on to pass.
I'll second.
Seconded by Senator Chandler, Senator Whitley. Is there any discussion? This bill really came at the request of GELCAR for the GELCAR staff, and it's a recodification of the emergency orders. So is there any further discussion on House Bill 266?
I will say that those GELCAR lawyers are some of the smartest lawyers
Oh, I know. We're lucky that we have them working for us. So we have an ought to pass on House Bill 266. Is there any further discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley, seconded by Senator Chandler. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay. I was going to ask Senator Bradley if you'd like to take this one out, but
Happy to.
no.
If it's on the consent calendar, I can.
Okay, all right, we'll have him do it. Make him earn his extra $25 every 2 years.
He gets to earn his mileage today.
Yes, he gets to earn it.
It's not every 2 years.
Okay, next we have House Bill 308 relative to a quorum for meetings open to the public, including remote presence. I believe there's an amendment to this
Yes,
as well.
I'll move on to pass.
Okay.
Second.
Okay, so we moved by Senator Chandler, seconded by Senator Whitley.
And if I may, I'd like to offer Amendment 1542. And I did speak with, I asked the question during the hearing of the prime sponsor if the intention was to have the public involved, and it seemed to be that was the intention as well. So what this amendment does is it says members of the public shall be permitted to participate remotely in remotely held state board meetings, including testifying or asking questions as the rules and procedures of the board allow. So it's not allowing, it doesn't change what the public's participation is. It just allows for them to participate in whatever the way they are normally allowed to participate remotely if members of the board are also participating remotely.
Okay, thank you. What is that amendment number?
It's 1542.
1542. Okay. Is there any discussion? Senator Abbas.
If I can just inquire about the amendment. Any concern about perhaps if you allow the public to participate remotely, that they're going to have people all over the country calling in?
No more so than I would have that concern with any meeting. And again, it does not allow them to participate in a way that they aren't already allowed to do so.
So, yes, please.
So are members of the public allowed to participate remotely already?
No, unless the board is allowed to have remote, some of the boards have had remote participation. This bill allows for the boards to meet remotely if they cannot achieve quorum otherwise. And this just says if they're going to do that and set up the remote participation, then they need to allow the public to do so as well.
We also need to address the language concerning reasonably practicable.
Oh, yes, I forgot to include that.
Maybe we could do a committee amendment.
Yes.
Yes. So, Senator Abbas, do you have any more concerns about the proposed amendment here on 1542S? Because we have to do a committee amendment, because we have to address the reasonably practicable language.
I have no problem with the language cleanup. I kind of take note to myself about opening it to the public all the way.
Mm-hmm.
I just know some of the hearings that I've either been involved in that had remote participation, you would have people all over the country. Now, granted, you get some great testimony from some folks who may not actually be physically present, but that also cuts both ways. So we didn't really hear much testimony on that issue, so I'm kind of, I'm not saying it's a bad policy, I'm not saying it's great, I'm just kind of thinking.
I think if we're allowing, it just allows public participation. And in many of these meetings, public participation is limited to observing. And if it isn't their policy to bring people in to testify, people would not have access to testify.
Senator Whitley?
Yeah, and I would add on to that, I think it should be in the authority of the body to make that decision about, whether they're just allowing members of the public to, when they allow members of the public to weigh in. And also, it's up to the body, the local body, to determine, to give weight to testimony. And it could be that, it's up to the body that they would prefer testimony from in-state. So I'm not concerned with that.
Okay, so we have to do a committee amendment. So let's look at the bill here. First, we need to, on line 14, page 1, line 14, in 2 different places, it says reasonably practical. We're going to change that to reasonably practicable. And then we will adopt the language from Amendment 1542S that Senator Chandley's brought forward. So that is a proposed committee amendment.
I'll second that committee amendment.
Okay, so it's been moved by Senator Chandley and seconded by Senator Whitley. Is there any further discussion on the committee amendment?
Just one question. So it's
Yes.
only on line 14, reasonably practicable.
Right, and
But
it's in
it's
2
twice.
places. It's at the beginning, and then the next sentence says, any reason that such attendance is not reasonably practicable. it's got to change there as well. And I believe that those are the only two places it is. It is on line 29, but it already says reasonably practicable. So we're just being consistent in the language. Okay? So we do have a proposed committee amendment with those grammatical changes, as well as adopting amendment 1542S as a complete committee amendment. Is there any further discussion on the committee amendment? Okay. Seeing none, all in favor say aye. Aye. Any opposed? Okay. So we have a motion of ought to pass on House Bill 308. It has been moved by Senator Chandley, seconded by Senator Whitley. Is there any further discussion on House Bill 308 as amended? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay. Is there a motion for consent calendar?
So moved. Second.
Okay, moved and seconded. Okay, all in favor say aye.
Aye.
Aye. Any opposed? Okay. Senator Chandley, would you like to take this one out?
Yes,
Okay.
Madam Chair.
Okay, something's going. Okay, next we are going to go to House Bill 491, and I'd like to move ought to pass on House Bill 491. Seconded by Senator Addis.
Great.
Is there any discussion on this? Senator Whitley.
I think this is a bill, long time in coming. I know that a lot of folks have worked on this issue for many, many years, including the Office of Child Advocate. She has done a lot, I think, recently in just giving us a real clear picture of the use of what restraints, and in particular prone restraint in facilities. And I think the community has identified a clear gap, and I think this bill really provides necessary clarification that will potentially save lives of our children. So I'm excited to vote for this bill.
Okay. Are there any further comments? Senator Abbas.
Thank you, Madam Chair. I thought it was really compelling testimony that the current law, when it was passed, the intent was to prohibit prone restraints. And due to the definition perhaps not being tailored enough, it fell short. So we're fixing that now. So this is a good policy.
And I'm glad to see it includes language that says that anyone who takes our kids, no matter where they are, if they're out of state, cannot use prone restraints, and that will be put into the contract. I think that's extremely important to protect our kids. Okay, so we have a motion of ought to pass on House Bill 491. Is there any further discussion on the bill, the motion? Okay, seeing none, all in favor say aye.
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 Any opposed? Okay, seeing unanimous, is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley, seconded by Senator Chandley. Is there any discussion on the ought to pass, on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay.
Next.
Oh, you want to take that one? Okay. All right. Next, we have House Bill 497. I'd like to move ITL.
A second.
Seconded by Senator Whitley. What I find with this is that it really wants to open up records that are still under investigation or has a concurrent law enforcement investigation. I don't think that's a good policy. And for that reason, I recommended the ITL. Is there any further discussion on the ITL? Okay. Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley, seconded by Senator Chandley. Is there any discussion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, I'll do this one. Okay. Next, we have House Bill 504, a bill we heard today concerning the Adult Parole Board and making an appropriation for. I'd like to move ought to pass.
I'll second.
Okay, seconded by Senator Chandley. Okay, is there any discussion on the ought to pass motion? I think this
Much
is really
needed.
more about the fiscal impact because of the money, but I do think the policy portion of allowing prior parole board members to serve in instances where someone cannot serve, I think is a good policy.
Especially since they've reduced their size.
Yeah, I agree. So, Senator Whitley.
Yeah, and I would say, it's not in HB 1 or 2, but it's on their surplus statement, so I'm glad that the House had factored it into their budget conversation.
Okay. So, we have an ought to pass motion. Is there any further discussion on the ought to pass motion? Okay. Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay. Senator Whitley, would you like to do this one?
Sure, do we move consent?
Oh,
Second.
okay. We have a consent motion moved and seconded. Is there any further discussion on the consent motion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay. Next, we are going to House Bill 583. I would like to move ITL.
Second.
Seconded by Senator Whitley. We always get a little concerned about bills when we have anything to do with child support, because it usually tends to be a pretty contentious issue. They do have a working group, and it's my understanding that the working group just really did not do anything with this bill, didn't look at it. I do think that there is a question of whether or not this bill is retroactive that needs to be addressed. So this bill is, in my opinion, not ready to come forward at this time. Senator Whitley?
I would agree. I think we also heard from the Child Support Bureau that they wouldn't even know how to describe the change in law to parents. And so we just can't pass something like that. It would make it even more confusing for parents.
Okay, so are there any further comments on the ITL motion of House Bill 583? Okay. Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a consent calendar motion?
So
Moved by Senator Chandler, seconded by Senator Whitley. Any discussion on the consent calendar? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, Senator Chandler will do this. Okay, next we're going to look at House Bill 588 relative to the criteria for applying for parole. I'm going to move ITL. Is there a second? Seconded by Senator Abbas. This really flies in the face of the truth in sentencing reform that was passed quite a few years ago. And if you really want to reform the truth in sentencing law, do it instead of just picking away at it. So that's where I am. Okay, Senator Whitley, then Senator Chandler.
So again, I think this came to us in really a compromise position. The House Committee, again, Representative Roy came to us and expressed how the House Committee had really grappled with this. They came to a compromise. They moved it from 50% to 65%. I think that was a great compromise. I think when you're looking at truth in sentencing, that was now 30 years ago, and once that passed, we saw skyrocketing incarceration rates. That was not a good thing. And so I think we have made efforts to reduce incarceration, to make sure all folks with our criminal justice system are getting what they need, treatment. I think that we have heard a fair amount, particularly from our Council of State Governments, about how parole is something that we really need to look at in New Hampshire. I think this was a really great first step, and so I will not be supporting the ITL.
Thank you. Senator Chandler?
I guess my sense of this bill is that the intention is really good. I did have some concerns with it, and I have the utmost respect for a number of the people who opposed the bill, as well as those who supported it. I do think there's an opportunity to improve this bill. I would have moved re-refer because I do really think there's opportunity here. Perhaps the way this bill is written is not perfect, but we also heard that there are people who don't have the opportunity to do the things that might help them reduce their sentence. So that's part of what I think needs to be additionally looked at. I would love for us to re-refer this if that were possible.
Thank you for
That's
your
not the motion.
comments, Senator. Senator Abbas.
Thank you, Madam Chair. The evidence we got at the testimony we got is that incarceration rates in the last 5 years has declined by over 20%. So we're doing a good job of reducing the incarceration rates. I'm not sure that we should go any further into that at least plateaus. But we also have the Earned Time Credits program that's been expanded. And we even can work on that and expand it more. That's also reducing sentences. So we've done a lot already. This may be one step, maybe too quick. I think it's a policy we should perhaps consider in the future, but I think right now is not the best time.
Okay. Thank you. Are there any further comments on House Bill 588? Seeing none, all in favor say aye. Aye. Any opposed?
No.
Okay. Senator Abbas, do you want to do this one? Yes. Okay. And the last one we're going to do is House Bill 624 relative to federal immigration checkpoints. I'm going to move ITL. Is there a second? Seconded by Senator Abbas. Okay. We have this when it comes to drunk driving and putting up the drunk driving checkpoints. We had something similar to this. I think it was in the last biennium about having the federal government require to notice public notice, and they had to notice local law enforcement. We're starting to have issues in our own state with illegal immigration coming across the border, our northern border. Why would we remove those checkpoints or make it, quite frankly, easier for people to come through? So I can't support this. Is there any other discussion? Senator Whitley.
Yeah, I think this is really common courtesy to do this. I think it's in line with best practice regarding sobriety. I don't think this will I don't think this will increase illegal immigration. We didn't hear any testimony in that. And further, I don't think we have a problem with illegal immigration on our northern border. Again, we just don't have that evidence that's New Hampshire specific. So I think this is a common sense issue. There have been litigation around these checkpoints. The federal government, there's a Supreme Court decision on it. And so I think there are problems with this process, and I think this is a common courtesy for our citizens, particularly in the communities where they are frequently. So I will not be supporting the ITL.
Thank you, Senator. Senator Abbas?
Thank you, Madam Chair. I just want to point out these are not checkpoints that the state of New Hampshire is setting up. This is the federal government. They're the ones that should provide the notice if there's going to be a notice requirement, and that's outside the purview of what we can do here. We heard testimony from a United States citizen who keeps getting stopped at one of these, and I can understand his frustration, but that's something that I would hope that our federal delegation can address.
Mm-hmm.
But for us to provide the notification, we compare it to drunk driving. Well, those are state laws. We're running those as whether it's state police or local police. I don't understand why we are going to take on that responsibility. I think that's a bit too much.
Okay, Senator Chandler?
I just want to say, but the federal law enforcement agency is the one that notifies the local law enforcement agencies, and that's what puts the burden on the state.
Senator Abbas?
I'm not clear if that's a requirement of the federal government. I think it's more of a courtesy. If you're going to be performing a federal law enforcement operation, that you let the local officers know, just so there's no misunderstanding what's happening. But at the same time, now to require the local police, even if they're not assisting in any way, we're still going to require them to provide a notice of what the federal government's doing. I think that's just a bit outside what we can do here at the state level.
And
Senator Chandler, yeah.
Thank you. And just in response, you said they are notifying the police as a courtesy, and I'd simply extend that courtesy to the community as well.
Okay. Senator Chandler? Senator Whitley, I'm sorry.
And I would say further that there's no requirement, the bill doesn't require, local law enforcement to inform the public if they aren't informed themselves. And so it's when they are informed, or if they are informed, then they are, obligated to give that courtesy to our communities, just like they do for sobriety checkpoints. So the other thing, I know this is the subject of sort of national politics, and I really don't want that to interfere with our decision-making, what's best for our own communities, and I do think this bill is a good one for our communities.
Senator Abbas.
I'm not aware of any other circumstance where the local police notify the public when the federal government's performing their law enforcement operations. This would be the exception, only this one. So anything else that the feds are doing, we don't provide such notice. So I'm not clear why we would make an exception here. And I haven't heard any reason why, other than that it's a courtesy. But we don't do that for anything else. So I'm just not hearing anything to change my mind.
Sure.
Yeah, and what I would say to that is that, as a citizen, I would want to know what the federal government was doing. And if my local law enforcement knows something, I think, this is a bill that's protective to our citizens. And I would think that we would want to do that as, elected officials in New Hampshire, to let our folks know when the federal government is doing something in our state. I think that's a courtesy that we could offer to our citizens.
So do you want to expand this to all operations?
So, Senator, these federal checkpoints have been the subject of litigation. They are problematic. There has been significant problems that have been identified with these. So absolutely, the bill before us is incredibly important because of the problems that have been identified already and addressed in law. So that's the bill before us, and I absolutely support it.
Okay. So we have a motion of ITL. Is there any further discussion on the ITL motion? Seeing none, all in favor say aye. Aye. Any opposed?
No. Yeah.
Okay, so 3-2. And Senator Abbas, do you want to do this one again?
Sure.
Okay. That is all I had for today. That's still
May I
a
ask
lot.
one question?
Yeah.
Sure.
We gotta let them.
Senator Whitley and I voted, I think, incorrect. I just want to make sure we don't need to recall that, because I think we both said aye and then no.
Yeah, can we vote?
No, no.
And I
It's
just
okay.
want to be
No,
clear how we voted. It was 3-2.
I saw you go, no, okay. No, you're fine. It's listed as 3-2.
Great.
So I
Thank
have
you.
it, and Mr. Schulze will make sure that
Thank you.
that's
I thought I
correct.
convinced my colleagues to change their mind.
I don't think so.
Well, I can,
Well, you convinced me.
Okay. So, is there a motion to come out of executive session?
So moved.
Okay.
second.
So all in favor say aye.
Aye.
Okay. We are out of executive session. We are done with our business for today. I look forward to next week when Senator Gannon will be back with us once
He was gonna be
again.
back next week?
Yeah, it's supposed to be
That's
back next
exciting.
Tuesday.
All
And
right.
we're only meeting one day next week, which is on Tuesday. We
Okay.
have our last bills we're going to hear. And then we will be in session on the 9th, and we will exec. So,
Great.
I'm not going to say au revoir. So,
Oh, right.
seeing that, we're going to conclude our business for today. Thank you all very much.